Welcome everybody to our webinar on current medico-legal issues you need to know. I'm Georgie Haysom and I'm the General Manager of Advocacy, Education and Research here at Avant. I'd like to start by acknowledging the traditional custodians of the lands on which we are all meeting this evening around the country and pay my respects to elders past, present and emerging, and also extend those respects to any First Nations people who are joining us this evening. So it's wonderful to have you on board. Welcome to those of you who haven't been to one of our webinars before, and welcome back to those of you who are regular attendees at these webinars. So I'm going to start by introducing our panel, and then I'll take us through our what we're going to do, the agenda this evening. So first of all, let me introduce Dr. Michael Wright. He is a general practitioner and the CMO at Avant. Michael, good evening.
Hi, Georgie. Hi, everyone.
Next, we've got Dr. Mark Woodrow. He is an emergency physician and the General Manager of our Medical Advisory Services and Deputy CMO at Avant. Good evening, Mark.
Good evening, Georgia, and glad to be here.
As we're a medico-legal organisation, we don't just have doctors, we also have the lawyers, and we have tonight Tracy Pickett, who is a senior lawyer with us. And she's got extensive experience in assisting doctors in medico-legal matters over very many years. Tracy, good evening.
Hi, Georgie. Hi, everyone.
And we've got a special guest star who wasn't on the invitation this evening. Because we're talking about that topic that you all are really interested in, or many of you are interested in, payroll, we have from Avant Law, Stephen Schoeniger, who is a specialist in employment law and the head of our employment and workplace law at Avant Law. Good evening, Stephen.
Hi, Georgie. Thanks for having me. Hi, everybody.
Awesome. All right. So this webinar is the first of our webinars in our 2023 series of general medico-legal updates. We very much appreciate your questions, and as you know, we like to use those questions to design the content of these webinars, which we have done this evening. So thank you. Please also add in your questions to the chat, and we will do our best to answer them as we go through. Okay, so what we're going to do first is we will get to payroll tax, but we're going to do that a bit later. There's a couple of other things that we want to get through first. So firstly, we're going to start with an update on Medicare, some information on what's been happening in the public policy space, reiterate the key tips on dealing with Medicare that we discussed in detail at our webinar last year. The second topic we're going to cover is one that we know is an area of concern for many of you, particularly in this customer-centric society that we live in. And we certainly saw a lot of it in COVID, and that is managing patient expectations. And in particular, you've told us that you want a bit more information about understanding how best to say no to patients when they make inappropriate requests. So we'll cover that. Then we'll get to payroll. And if we have any time left, which I doubt, but nevertheless, you never know, we'll catch up on a couple of the general medico-legal questions that you have asked us prior to the webinar. All right, so I'm going to stop talking soon, I promise, and move on to our other people. But first up, we're going to do a quick poll question, as we always do, to kick ourselves off. So if we can put up the poll question, it's in relation to Medicare. So how confident are you in your dealings with Medicare? Are you not confident, somewhat confident, or very confident? So while we're waiting for those results, last year, many of you may have seen the education campaign that we ran on understanding Medicare and compliance, and we produced quite a lot of educational content, including discussing that at our last medico-legal update. If you missed it, it's on YouTube, so you can certainly get access to that. And all the material that we produced is available on the Avant Learning Centre. So we'll get to the developments in a moment. I think that's probably the poll that we can end now. And let's have a look, and we'll share the results if we could, please, to the elves in the background. All right, so we have 23% of people not confident with dealing with Medicare, 69% somewhat confident, and 7% very confident. Well, I'm very pleased to see that there's a few of you that are very confident with dealing with Medicare, which is awesome. So I'm now going to turn to Michael, and I'm going to ask you a couple of questions, Michael. firstly, what are your reflections on the poll answers? And secondly, can you give us an update on what's been happening?
Hi, Georgie. Look, I think firstly, I'd say congratulations to the 7% who are very confident. I think the fact that a lot of our members still are somewhat confident shows that there is an ongoing need for more Medicare education, and perhaps we can continue rolling it out. So if you haven't seen the YouTube video, please go and look at it. I suppose just to update you in terms of that Medicare campaign, we particularly focused on where you find the right information for using Medicare items and also about compliance issues. And we surveyed members before the campaign, and over 1,500 of you responded and told us where your main pain points were. And they were about understanding individual item numbers and also a need for support in sort of understanding how to navigate the Medicare compliance system, whether it be through a review letter or more higher level compliance. So we've updated all our FAQs and we've developed some new information which we can pop in the chat, which includes an update on Medicare claims insights, and we've completely rebadged all of our Medicare content on our website. So both of those will pop up in the chat. And I suppose we've finished that campaign for now, but it has actually given us a really good advocacy position in that some of you will be aware that there were media reports which suggested widespread fraud of the Medicare system last year. And subsequent to that, the government engaged Dr. Pradeep Philip from Deloitte to undertake an independent review of the Medicare system. Now, we've had the opportunity to present to that review. We've also shared our experiences that in the majority of cases, we think that Medicare compliance is inadvertent. It's due to the complexity of looking at Medicare, and that fraud is very uncommon. And we're actually able to share the results of the survey that showed that. And what we shared was really well received. So I'd like to thank everyone for completing the survey. And that report from the Medicare Integrity Review is currently with the government, and we're expecting that to be released very soon. And when that report and its recommendations come out, we'll provide an update to our members.
Great. Thank you very much for that update, Michael. Was there anything else you wanted to add there, or?
No, look, I think that's it for now. Like, as I said, the campaign was really successful, and we've also got some follow-up results of the survey, which are showing that the education we provided has improved many of our members' understanding and confidence in dealing with Medicare. I suppose it's provided strong evidence that there is a real need for education and support rather than punitive compliance activities.
Absolutely, and that's certainly something that we've been very big on, really, is making sure that people aren't punished and that there's a lot of exercise put into or efforts put into education. I'm going to turn to Tracy now. Tracy, can you give us just a bit of a quick recap and update in relation to Medicare, following on from what Michael said?
Sure, Georgie, and I might just add, education is key focus for us at the moment, and we have been liaising with the Department of Health's education team to look at programs which we might be able to assist them to share about the fundamental principles which underpin the MBS system. So that would be programs to increase the knowledge of the central rules of the MBS system, to provide some clarity to doctors. So we hope that would be forthcoming in the near future. But in the meantime, we certainly received a lot of interest from members regarding Michael's recent article, which was titled Tips to Avoid Medicare Compliance Issues. And it basically summarised 5 key areas to focus on to try to avoid compliance activities. And those recommendations were, first, quite obviously, to understand the item number. And that's critically important because as a provider, you are the one responsible for the claims to Medicare, which are made under that provider number, irrespective of who does the billing for you or who receives the benefit of the funds which are claimed. Therefore, you need to be confident that you're claiming under the correct item number and that your consultation records reflect the elements required for that item number to be charged. Second, you must ensure that those records are adequate and contemporaneous, and that is, they must reflect the requirements of the item number that are claimed for, and also that another practitioner could consider those records and then take over the patient's care. So a failure to keep adequate and contemporaneous medical records may result in an audit finding, or that a finding that the benefits ought not to have been paid, and the government might seek repayment of the full amount of those benefits and possibly a penalty. Third, you need to check that all of the billings under your provider number have been appropriately made, and we recommend that you check all and any claims billed under your provider number at the end of each day, and that you keep those records for 2 years, because there is a 2-year time limit for the lodgement of claims. So if you move about from practice to practice, it's possible that claims could be audited after you've left a practice. So we recommend that you keep a copy of all the reports for claims submitted under your provider number for 2 years, so you can respond to any future audit requests. Fourth, you need to be confident that the service you claim for is appropriate and clinically indicated. Particularly, you'll be aware that chronic disease management plans and team care arrangements have been particularly heavily scrutinised by the department. So if you were to be audited on those item numbers, you'd need to demonstrate from the records that the service rendered was clinically appropriate and that all of the requirements were met. And for that reason, we don't recommend that you seek to recruit patients to care plans without the appropriate clinical basis, and that any plans you create are tailored specifically to that patient and document their baseline assessments or individualized goals, and document the patient's consent and appropriately identify the disease being managed. So it's tailored to the particular patient. Fifth, you need to stay connected to your peers and ask for feedback, and that is because it's a determining factor to show that the services billed are clinically relevant. And one way you can satisfy that requirement is by keeping in touch with your peers and making sure that your practice is consistent with those commonly accepted standards. So all of that information is on our Avant Learning Centre under the Medicare heading. And just before I finish, we had received a question from one of tonight's audience members, which was, has there been any update on phone billing requirements? I think that question relates to the option to obtain verbal consent to bulk bill telehealth consultations. That had been due to end in December 2022, but it was extended for an unspecified time. The Department of Health website still says that you can get a patient's agreement to bulk bill item numbers in writing by email or verbally, but notes that getting verbal consent is a temporary policy measure and that you must keep a record of the agreement, and you must note unable to sign in the patient's signature field and note why the patient is unable to sign. So they give an example of a reason why the patient is unable to sign as being COVID-19. However, in the case of a telehealth appointment, you'd record telehealth consultation, but you should also record in the notes why the consultation was convened by telehealth and that it was clinically appropriate to do the consultation in that manner. So while it's still possible to seek verbal consent to assign the benefit, we recommend that you subscribe to the department's website to ensure that you receive an email notification if and when that position changes. Thanks, Georgie.
Great. Thanks very much, Tracy. We've had a couple of questions in the chat. There's a really good one for clarification, I think, which was around the record keeping requirement, where you mentioned, Tracy, that there's a requirement to keep the records for 2 years. And the question was whether or not there's differences between children and adults. I just wonder whether that question might be around general medical records keeping requirements. So can you just clarify that situation, please?
My response about 2 years is about the lodgement of claims. So Medicare does audits as to the item numbers billed. And so you can lodge item numbers for whatever patient up to 2 years after the consultation date. The recommendation as to different retention dates for medical records relates to children and adults, and that is when you can destroy the record. So that's a little bit different, but I might add that there is a good resource on the department's website, which I'll try and find and put in the chat, about adequate record keeping.
Great, thanks very much, Tracy. I have another question for Michael. And Michael, with the recent 10997 target campaign for GPs, what's the advice of the panel in responding to that?
Thanks, Georgie. Look, this was a recent Medicare compliance campaign, which was asking predominantly general practices to reflect on their use of practice nurse items when they were co-billed with chronic disease items. So we've had a number of calls from members and practices wanting advice from our Medico-legal advisory service. And we've already fed back to Medicare that the campaign could have been better explained and better targeted, as it's sort of created a lot of anxiety. And the wording is a little bit uncertain in the Medicare guidance about whether you can do them or not. And Medicare says we wouldn't expect that you would normally co-bill them together, but there are exceptions where you could. So potentially if you had provided a separate service that required the 10997 beyond what the health assessment or the chronic disease management plan was, you could co-bill them, but they need to be clearly documented.
Right.
So I'd suggest people have a look at those letters and look at their result and look at their documentation to see if that applies to them.
Great. Thanks very much, Michael. There's a couple of other questions in the chat. I did want to ask one of them. We'll try and respond to them directly to the people who've asked them, but there is one about, Tracy, I might ask you this one, or Michael could answer it. It's about who's liable in the event of an audit where there's MBS funded public hospital clinics, given that the hospital never provides a list of the patients or item numbers that are claimed. Tracy, do you want to take that one first?
If your provider number's involved, then you are responsible to respond to the audit. Now, whether a response might be given that you weren't aware that the practice was happening, that may be open to you, but fundamentally, every person who holds a provider number is responsible for the item numbers billed under that provider number.
Great, thanks, Tracy. And Michael, just any tips on how to deal with that situation?
Yeah. That's what I was going to say, is that you are still responsible for everything billed under your number, and you shouldn't, even if the hospital doesn't give you access to the patient list, you should be able to look on Medicare to work out what has been billed under your item under your provider number to provide you with some sort of clarity or reassurance.
I might say, Georgie, anyone who has a question like this, or if people become aware of a practice that they're not sure of at their hospital, please call the Medico-legal advisory service and we can assist you there.
Great, thanks, Tracy. That's a great piece of advice. And as we mentioned, there's lots of material and our prior medico-legal update that you can have a look at for some more answers to your Medicare questions. We're going to move on to our next topic now, and I'll be able to hand over to Mark Woodrow. But before we do that, we'll do another poll question. Our second topic, as I mentioned, is on managing patient expectations. So if we could get our second poll question up there, please. So have you had situations where saying no to a patient can be a challenge? And if you can answer that question, what we find in our claims data is that in many cases where the patient makes a claim or a complaint about a doctor, when the doctor's conduct's reviewed, they've actually done the right thing in quite a lot of cases. So, you know, we're always interested in why patients might bring a claim and complaint in those circumstances where clinically everything's been fine. And we do think that one of those reasons is a mismatch between the doctor's expectations and the patient's expectations about what might happen. So I think, how are we going? That poll's still going. So we're going to explore that in a little more detail now. I'm going to hand over to Mark in a second. Let's have a look at the results. So yes, so lots of people, 23%, that's quite a large number, who often have situations where saying no to a patient has been challenging. 75% occasionally have that situation, and the 10%, I'm loving this little minority of doctors in these polls. Actually, you're very lucky that you've never had a situation where it's been challenging, and it would be interesting to know in the chat, you know, how you deal with those situations. So I'm going to hand over to Mark now, and Michael also, but first to Mark to talk a bit more about managing expectations and how to say no to patients. Over to you, Mark.
Thanks very much, Georgie. Well, we all know the situation, the patient who insists on a prescription for antibiotics for a viral sore throat. Well, they got them the last time they saw a doctor. Or the patient who's demanding increasing doses of opioids for their chronic pain. It's the only thing that'll work, doc. Or how about the patient who insists on having an AMH test when they're in their 20s to to determine their fertility. And doctor, the cost is not a barrier. I need to know when I should have children. One of the best requests I had was from a patient who demanded to have her tubes tied at the age of 17, in the understanding that she could have the clips removed later when she wanted to have children. As you know, a lot of what we do is managing expectations, and it's the failing to meet these expectations that leads to most complaints. Most times, patient expectations are clear and they're aligned with what we hope to achieve. The difficulty is patients arrive with their expectations already formed, and often they may be unclear, hidden, misconceived, unrealistic, or even irrational. Our job is then to discover what the patient expectations are and realign them if needed to hopefully achieve an outcome that's not only beneficial for the patient, but also acceptable to them. It is important to be respectful of the patient's expectations, even if they're not appropriate. They're rarely formed out of malice, more often misunderstanding. Communication is, as always, the key. If you find it hard to say no to patients, well, you're not alone. Some will find it harder than others, particularly when you genuinely want to help. And this is a challenge in all areas of clinical practice. However, there are ways of making it easier, and a way that you can do it to maintain a good therapeutic relationship. You are expected to use your clinical judgment and only provide care that is clinically indicated and likely to benefit the patient. Always agreeing to a patient's request, especially when you disagree with it, may reduce patient dissatisfaction in the short term and avoid conflict, but doing so may not fulfill your ethical and professional obligations. You should be giving the patient what they need, not necessarily what they want. And this may mean saying no. So being able to say no effectively while maintaining a therapeutic relationship is possible, and consider the following suggestions. First, and it seems somewhat trite and obvious, listen to the patient. Ask the patient about their symptoms and the reason for the request. Even if you ultimately decline to prescribe a particular medication or offer a test, you need to find out what else is going on. You and the patient may be able to agree on an alternative approach or a course of treatment once the patient's expectations and perspective are explored. Research suggests when patients feel heard and respected, even when they don't receive the treatment they requested, they generally report greater satisfaction with the consultation and may be less likely to complain. This accords with Avant's analysis of claims data. In our experience, complaints where the primary issue was patients not having their request or preferences met, more often than not, it involved a secondary allegation of disrespect. Secondly, you should carefully consider their request and explain your reasons. Unreasonable requests can often result in a very emotional response in you, especially if other factors exist, such as being hungry, angry, late, tired, stressed, especially at the end of the day when decision fatigue sets in. And this requires some insight and understanding about yourself and the possibility of cognitive biases. Make sure you haven't jumped to the conclusion about the reasons motivating the patient's request. Wait until you have asked the necessary questions and have received the patient's response before you reach a decision regarding the patient's request. Having heard the patient's perspective and concerns, if you still believe the treatment is inappropriate, be willing to give a firm no so that there is no misunderstanding. And again, try to do so respectfully. Offer an explanation. Make sure to use everyday language, avoid medical jargon. And it can be helpful to say why you are concerned. For example, if you believe a procedure is too risky, or otherwise explain why you consider that the treatment is not in the patient's best interests. If possible, try to explain and avoid the use of the words but or however. I'm not sure if people have heard the expression before, but 3 buts are an argument. Instead, try redirecting the discussion by substituting the word and, or simply pausing and starting the next thought. Keep it professional and stand your ground. You are the expert. Try to remain calm and professional in your dealings with the patient, and be aware of your own mental state and body language and how that is affecting your reactions. Make sure you understand any legislative restrictions, for example, those associated with prescribing drugs of dependence. Keep your own clinical knowledge up to date. and that'll give you confidence in your decision. In response to one of the questions we had received, it is important to maintain your professional boundaries, and we covered this in the previous webinar as well. Saying no is even more difficult if your professional objectivity is compromised, which is why we recommend doctors avoid providing care to anyone with whom they have a close personal relationship. So if the situation is unable to be resolved, as sometimes occurs, you can always transfer the care of a patient to another practitioner in the patient's best interests. Unfortunately, you cannot transfer a friendship or a professional relationship. It is also important to support your team and manage psychosocial risks. Doctors sometimes tell us that they've put their foot down with a patient only to find themselves unsupported by colleagues or practice policies. From a practice perspective, it will be important to consider the psychosocial risks some of these scenarios can present to other doctors and staff, and consider any changes needed to help manage this. Occasionally, despite best efforts, patients will not be satisfied and may become angry or hostile. Of course, it is important to consider each patient's circumstances individually. However, if your practice has consistent policies, communicates these clearly, it will be easier to manage patient expectations early and reduce the risk of confrontations. It is also important for the practice to consider how to manage any potential issues if the patient becomes upset. Options may include training, managing appointment bookings, or consider the layout for the practice waiting room. And finally, as you'd expect from a medico-legal webinar, document carefully. Carefully document the conversation in the patient's medical record, including the reason for declining treatment and any other alternatives that you have discussed. Patients who do not get the treatment they were hoping for, that is, they don't have their expectations met, may ask for a second opinion or they may complain. Detailed records will help you if your decision is reviewed by someone else after a patient complaint. So while most of these concepts are fairly generic, I recognise my personal experience is in emergency medicine, where I'm usually meeting the patient for the first time. So how does this resonate with you, Michael? What would be your perspective in this circumstance?
Well, thanks, Mark. I suppose I'm often fortunate in general practice in that I've got access to an existing medical history, and I've frequently had the opportunity to meet someone or their family before and probably got an understanding of their situation and potentially built some rapport. So that probably allows me to understand where unusual expectations might come from, which probably is an advantage, but there's always a new patient around the corner. So I suppose the principles are the same. Listen to the patient, be professional, keep you cool, and then document what you've done.
Thanks very much, Michael. I might jump back. Well, I have already jumped back in here. Uninvited, unannounced. Here I am back. There are a couple of questions that I did want to run through. There's one that I think I might be able to answer as the third lawyer in the room. It's in relation to a question about, what happens if a patient is asking for or demanding tests that have been suggested by someone else, in this particular circumstance, someone who's a naturopath, but it can occur, sometimes the patients, as you are well aware, will find stuff on the internet and then they'll say, I want to have this treatment or that treatment or whatever. And what do you do? From the legal perspective, there's no obligation to provide anything that you consider to be not in the patient's best interest and not clinically indicated for the patient. And, really, I don't think it's a defense. It's not a defense to say, oh, well, the patient asked me for it. Any referrals that you make or any medications you prescribe, you have to exercise some clinical judgment as to whether you think that's appropriate. And so I think that's one of those circumstances where, it's an inappropriate request and you do have to say no. So Michael, that probably happens a bit in GP land. How do you deal with that?
Yeah, that fits pretty well, Georgie. I mean, there are often times that patients request tests, referrals for things that I wouldn't support. And I can say to them, look, I don't think they're clinically indicated. And then importantly, I can't bill them through Medicare. So often even that's a way to manage the expectations, because often when people find that they need to pay for something that they've otherwise requested, they're often less keen to proceed with it.
Thanks. Mark, you want to say something?
Yeah, I'd agree with that. Obviously, once again, harking back to the first couple of points, it is important to, listen to the patient, because their request is usually born out of some misunderstanding rather than malice or some other subterfuge. So it is important to listen to the patient, and you may be able to identify the reason for the request and address that itself. Sometimes the patients will come with that expectation and they will not be swayed, and this is very difficult. But again, as Georgie mentioned, it's no defence to say that the patient insisted on it, so therefore I gave it to them, particularly if something goes wrong subsequently.
Thanks very much, Mark. Tracy, I was going to ask you a couple of questions. There's one around, I'm not sure whether this is one for you, but it refers to minors who might need help and their parents are separated. It's a very complicated situation, but I think I just want to ask you the question around what you do when you're treating minors in the absence of their parents. What's the rule around treating young people?
Yeah, young people, I take from the term minors that they are children who are not mature minors and therefore don't have the capacity to make their own decisions. I've seen that question, and what I would suggest is that the doctor calls in tomorrow to the Medico-legal advisory line. This happens quite a bit, and what is important is that we make an assessment as to the minor's capacity. If they don't have capacity, we need to find out what the current custody orders are for the child, who has custody, and then we need to engage with them. And if they're not engaging at all, we need to work out what further steps are necessary depending on the minor's clinical condition. But it is reasonably complicated, so please call in and we'll walk through the situation with you.
And similarly to the doctor who's asked the question around separated parents and differences of opinion around what treatment options should be given to the child, this is a sort of question. So separated parents is a question we get really quite frequently on our Medico-legal advisory service. So absolutely give the MLAS service a call, and then we'll we can give you some advice. Tracy, sorry.
Yeah, the first point of call is to ask the parent for the current custody orders for the child. That's the starting point. So do that, and then we'll work out what the next step is.
Okay, great, Tracy. All right, so according to my little run sheet and timetable, we're going to move on to our next topic, which is the one that many of you have been waiting for around payroll tax. If we've got some time at the end, we'll come back to some of the questions that you've asked. They've been very helpful questions. We've responded to quite a few of them, but there are some more general ones. So this one is potentially the most complicated one that we're going to be dealing with tonight. If you thought that some of the stuff that we were talking about with Medicare and separated parents and saying no to patients was complicated, this one is particularly complicated. So we've received several questions about payroll tax from you guys when you registered, and I've kind of put them into 4 categories that I'm going to talk to Stephen about. So the first one is which doctors it relates to. So is it just GPs or other non-GP specialists? Which states is it relevant in? What sorts of arrangements does payroll tax, do the payroll tax issues apply to? And we've had some questions around, is it applicable to employees? Are we talking about contractors? Are we talking about sole traders? Are we talking about companies? So we'll try and cover off some of those things. And then what steps can be put in place to mitigate the risks of having to, the risks of a payroll tax liability? We've also had some questions coming in about doctors having their own websites and others about billing and payment arrangements, which are all sort of indicia of whether it's an employment contract or a contract and the like. But Stephen's the expert. He's going to take us through that. 2 things to do, or 3 things to do actually before we move on to that. First thing is to confirm that this is general information. It is a very complicated area. So the advice that Stephen, or the information Stephen's going to give, is very general information, and you should absolutely get your own advice from your accountant or from a lawyer in relation to that. And we'll talk about that in a bit more detail at the end. And then the second thing that we wanted to have a look at was a poll question, actually. And so we'll put up that next poll question. And that is, how concerned are you about payroll tax issues? And we've got one of the standard sort of scales there. So if you can answer those questions. And while we're waiting for that, I'm going to turn to you, Michael, which is the third thing I said we'd do before we turn to Stephen. There have been lots of reports in the media about payroll tax issues. And as I mentioned, we've received lots of questions about it. So can you just give us a bit of an overview from your perspective as a general practitioner and a doctor, what is this thing called payroll tax?
Sure, Georgie. Yeah, look, it certainly has been in the media a lot. So put it in basic terms, so payroll tax is a state tax that businesses pay based on the amount of payroll paid to their employees. So there are varying thresholds for when the tax applies. So it ranges between sort of 4 and over nearly 7% in some states, and then varying thresholds of when it kicks in. It's as low as $700,000 in Victoria and up to $2 million in the ACT. So basically, it's a state tax payable on those taxable wages, which includes payments made to employees, as well as payments made to, and this is where it gets a bit technical, made to some contractors where they're engaged for their labour under a relevant contract. So previously, sort of the typical arrangements of most GPs and most medical practitioners working in medical centres where they provide a service to a practice and the practice takes a percentage of billings was thought not to be subject to payroll tax, as the medical centre and the medical practitioners were sort of two separate but interdependent businesses. But recently there have been some rulings which have been suggesting that payroll tax may apply under some of those arrangements in some practices. So that's sort of the summary, but I think we'll hand over to the expert.
Mm-hmm. Absolutely. So we're going to just share the results, if we can do that, of the poll. So 30% very concerned, 37% somewhat concerned about payroll tax, 15% not concerned, and 18% what's payroll tax. So I thought hopefully you'll have an understanding after Michael's discussion there, and more understanding after we get Stephen on board. So there has been a lot, as we said, in the media. There's been some reports, and there was a recent case last week, I think it was, handed down on payroll tax. So I'm going to turn to Stephen now. And Stephen, can you start by giving us an overview of the current legal landscape in this area of payroll tax?
Absolutely. Thanks, Georgie. Michael has neatly recapped for us what payroll tax is. It's a state tax that businesses are required to pay based on the total value of their payroll. All states and territories have payroll tax laws, and they are largely harmonised around the country, but there are tweaks and differences between other different jurisdictions. WA is the state that is most different from the others, where there is largely harmonisation, but again, differences between the states. And the cases that have received the most attention, and including obviously the payroll tax ruling that has come out of Queensland, are mainly focused on practices on the East Coast, where the laws are sort of part of that most harmonised group. Where the laws around payroll tax nationally cause a lot of confusion is, as Michael has indicated, that the laws are talking about employers paying tax on the taxable wages paid to their employees. Now, under the payroll tax laws, just like our superannuation laws, these words don't have their usual meaning, and there are specific definitions applied to them in the legislation. There are expanded statutory definitions of wages, of employer and employee, that are extending payroll tax to payments made under much broader working arrangements for the performance of work. And with respect to doctors, who are people being engaged to provide personal labour, and that is classically arising in relation to a simple employment relationship. So doctors working at medical practices under services and facilities arrangements are not being considered employees in the normal sense, but the agreements in place between those doctors and the practice where they are running their own businesses are being considered relevant contracts, which are consequently making them subject to payroll tax. And they're being considered relevant contracts because, again, we're looking at individual people who are being engaged to for their own labour under the relevant contract that's in place. To address a couple of the questions at this point that we've received before today's webinar, individual doctors don't pay payroll tax. The liability is on the practice. And when we talk about practices, we're talking about all medical practices, not just GP practices, specialist practices too. And liability also extends into allied health, where it's also not unusual for similar service agreement arrangements as we're used to in relation to the medical profession also existing. So the current pointy end of developments around payroll tax for medical practices are the latest decision that Georgie referred to that came down just last Tuesday, which was the latest appeal in the series of Thomas and Nas decisions in New South Wales, and also the Queensland payroll tax ruling that I'm sure many of you have heard of, applicable only in relation to practices in Queensland, but we've now had an amnesty announced by Queensland Revenue, formally announced for practices in Queensland. In relation to Thomas and Nas, to deal with that one first, it was a very hotly anticipated decision. It was a decision because it was an appeal that was heard by the New South Wales Court of Appeal. So a very superior, one of the most superior courts, where a decision will be binding on other courts and tribunals. Unfortunately, we haven't received from the New South Wales Court of Appeal the clarity that we would have hoped for, and that is because the case was unsuccessful in its appeal for technical legal reasons completely unrelated to the question of payroll tax itself, which saw the court refuse leave to appeal to the Thomas and Nas practice. However, in the course of the judgment, the New South Wales Court of Appeal did make some interesting observations on the question of payroll tax. And in particular, the court observed what a lot of lawyers and accountants and tax specialists working in the area have been saying, that the direct payment of fees by patients to the practitioner's bank account, as opposed to a consolidated practice bank account, would appear to mitigate the risk of payroll tax for the practice. And this is because in Thomas and Nas, the Court of Appeal did observe that there were three other allied health professionals in relation to those three people working at the practice who were receiving direct payments, and New South Wales State Revenue had not levied payroll tax on those amounts. So the court made that express observation. So that is really highlighting that the flow of funds between the parties, between the patient, the practice and the doctor, is fundamentally important to the payroll tax question. Now, money alone is not the definitive answer for practices. This is because there are also other relevant parts of payroll tax laws that were not considered by the New South Wales Court of Appeal because they didn't arise as an issue in the particular Thomas and Nas cases. And that includes other parts of the legislation that deal with things like third-party payments, so Medicare benefits being assigned to the directly to the doctor by the patient. So at the end of the day, it's always going to be important for cases to take their own legal, tax and accounting advice, depending upon the way in which you are working operationally. But the emphasis on the flow of funds that we can certainly take away from Thomas and Nas also does not take away from the real importance of looking at the totality of the practice's arrangements with its doctors, especially given the various issues raised in the famous Queensland payroll tax ruling targeting medical practices, which gives us an insight into obviously what we would expect that the revenue officers in the other states and territories around Australia are going to be very closely monitoring, with a view to probably looking at their own rulings that are relevant. So if we think then about the Queensland payroll tax ruling and the lessons that we can draw from that, taking into account not just the Thomas and Nas series of cases, optical superstores is another case, one of the key cases that many of you will have most likely heard of, and the related litigation gives us quite a few takeaways. And so if we step back from talking about money alone, the key overarching takeaway that I think comes from looking at the cases holistically, as well as the Queensland ruling, is that as a practice, by imposing restrictions and more employee-like requirements on a doctor, it is going to be more likely that the practice is seen to benefit from the services being provided by the doctor, meaning that the doctor is, to that extent, seen to be providing services to the practice. And so we are, in that sense, walking into the arms of the State Revenue Office, because it's much easier for State Revenue in your relevant state or territory to be saying that your practice is deriving tangible benefits from the work this doctor is performing, almost separate and distinct from the medical services that the doctor is providing to patients independently, which is the core of the foundation of service agreement arrangements. So again, it's the more we want to be, as practices, I suppose, controlling the way that doctors are working, the more likely it is generally that we are tiptoeing into dangerous territory when it comes to payroll tax. So from the cases and from the ruling, some of the obvious takeaways that we can all take on board, I think, are that firstly, you always want to be getting your agreement in writing and signed. It's very dangerous to be relying on a verbal agreement with any particular service provider. Medical revenue must be being received wholly. Excuse my voice, I've been talking and presenting for 2 days straight. The revenue must be being perceived wholly by the practitioners who are engaging with the medical centre under a service agreement. That is really fundamental. We can't be receiving the funds into a practice bank account. We want to avoid trying to be rostering or specifying hours of work for the doctors conducting their own practices, as opposed to agreeing with them based on the availability of your consulting rooms and your hours of operation when they wish to make use of those services and practice from your practice. We want to be avoiding non-competition restraints and restrictions on the solicitation of patients after the doctor has ceased at the practice. These are quite common, but they have been taken in the cases as a strong indicia of employment, because and employment in inverted commas when we're talking about payroll tax, because the interest in the practice of preserving its customer relationships, patient relationships, are really arguments that come back to bite us in practice legally, because a doctor running their own practice and providing medical services to the public at large is the party to whom the patient properly belongs, so to speak, in a legal sense, rather than the practice. And so that is a term as well that we often see reflected in service and facility agreements, services agreements, where these sorts of arrangements are coming into question from payroll tax perspectives, is that the temptation is to say that the medical records should belong to the practice. Again, because the doctor is running their own practice, the medical records should belong to the doctor. You would put in place clear licensing arrangements to retain that intellectual property as a practice for record-keeping purposes, for continuity of patient care, where a patient may well be seen by another doctor where their own doctor is not available. So there are ways around some of these things, but we can see that where we are rostering, specifying hours, trying to put in place post-employment restraints, wanting to control the flow of money naturally so that we can know we're getting paid. These are the things that are all indicia that are treading on the toes of the payroll tax legislation and are really the focus of the state revenue officers, as really clearly comes through for those of you who've had the opportunity to look at the Queensland payroll tax ruling. The final point I would make in terms of, I suppose, the latest developments relevant to payroll tax outside of the Thomas and Nas Supreme Court decision from last week in New South Wales is relevant for those of you in Queensland, which is that the Queensland Revenue Office has now officially confirmed that it will provide a payroll tax amnesty on payments made to contracted general practitioners until the 30th of June 2025. The important information or qualifications around that is that it is a limited amnesty. It's limited to contractor payments made to general practitioners in Queensland only. It's only available on application by the practice, so it isn't applying automatically. Critically as well, the amnesty is not available to other medical doctors or allied health professionals. It is only for general practitioner contractor payments. So if you're operating a specialist practice in Queensland, you are unable, unfortunately, to take advantage of the amnesty, and it will be important to be taking specific advice on your practice's particular arrangements with your specialists. Georgie.
Thanks, Stephen. Wow. It is very complicated, and but you explained it in a really nice, succinct way. Hopefully that will have covered off a lot of the general sort of questions that people had about this. We've had a couple of questions in the chat that I just wanted to ask you about. I'm just trying to flick through. Someone asked this: does payment to the receptionist and the practice manager, and I guess by implication staff members, attract payroll tax?
The wages or the salaries paid to the employed practice manager, receptionists, any employed nurses will attract payroll tax where your total payroll is hitting the relevant threshold, depending on your state or territory. If that's the point you made there. Obviously, in relation to the, I suppose, facilitation of payments being made directly to the doctor, that would be a key aspect of the services being provided by the practice legitimately under I suppose, a pure service arrangement, so to speak, in that, reception would, process the patient's payment into the doctor's bank account in the ideal scenario.
Yeah, great, Stephen. And then another one that came through is, if doctors aren't being seen as contractors but employees, should we be paying super, holiday and sick pay? That might be a bit complicated to answer. No, I don't know, but can you answer that one?
I can hopefully give you a quick answer, and I think this is where we have to be very careful, because this is where the confusion comes from the language of the payroll tax legislation. So where the State Revenue Office is saying that you owe payroll, the practice owes payroll tax in relation to the doctor, it's looking at the nature of the contractual arrangement. It is not saying that the doctor is actually an employee by law. So it's the language, unfortunately, that the legislation uses that causes the confusion. So a doctor who is engaging your practice to provide administrative services and nursing support to the extent that that is provided is legitimately contracting with your business, and you are providing services to that doctor. It is highly unlikely that doctor, where you have a written contract in place documenting that arrangement, is going to be an employee in the general sense of that word. And so in those circumstances, annual leave, long service leave, the benefits of employment are not available to that doctor. Superannuation is a different boat, and the superannuation laws similarly use deeming language around the obligation to pay superannuation. And so those laws are capable of applying to even pure contract service agreement arrangements. It depends on the individual circumstances of the doctor. But again, the general principle, just like Michael described in relation to payroll tax, is where an individual is engaged to provide their own labour, then on face value, superannuation will be payable, whether they are an employee or a contractor. But there are some caveats around that and tweaks around that you should get specific advice on for your practice.
Thanks very much, Stephen. I'm going to turn to you, Michael. We've had a couple of comments in the chat, and I know this is an issue dear to your heart and something that we're considering at Avant, which is the significant impact this is having on GP practices in particular, in terms of the sustainability of general practice. Particularly, I think it's fair to say, after the stresses of COVID, probably not just general practice, but I know that it's felt hard in general practice land. Do you want to make some comments on that, Michael?
Yeah, thanks, Georgie. Look, you're right. I think many general practices feel really burnt out after dealing with the pandemic, and there's a lot of concern about the decreasing viability of general practices. Medicare rebates haven't kept pace with costs, particularly during the pandemic. So there's a real problem with the financial viability of general practices. We know that the AMA, we know the RACGP and other colleges are sort of looking at this, and they're trying to get some sort of a definitive answer. Whether that is a long-term amnesty, obviously, is ideal. We had a couple of questions about people saying, you know, do we just increase our fees? And potentially things like that is, you know, may have to be a real option depending on if practices can set up their contracts in a certain way. But it's a real challenge. And I know, look, at Avant, we are lobbying. We have been, you know, talking to both state and federal health departments, raising the concerns, highlighting that this is a real issue. We've got the federal government on one hand with their Strengthening Medicare Task Force talking about putting additional investment in general practices, which won't help a lot if payroll tax suddenly reduces between sort of 4 and 7% from practices with the other hand.
Great, thanks very much, Michael. As I mentioned earlier, it is very complicated, and what we've said is just really touches the surface of the complexity that is around this particular issue. We've put a few links into the chat, and we will send them out after that, you know, when we send it out with the recording of this particular webinar. But absolutely, if you need specific advice, take advice from your accountant. Probably in the first instance, many of the questions that you asked the people have asked in the chat have been accounting type questions. So go to your accountant and ask advice about that. Certainly, if you need some specific legal advice in relation to this topic, I need to let you know that it's not covered under our medical indemnity insurance policy, but we do have, and partly why Stephen's here also, is we do have our new services through Avant Law that provides services to members and others, in fact, not just members. Stephen could probably give a bit more information about this for a fee. Stephen, did you want to make any further mention about that and about the sort of advice that you might need to get in this space?
Absolutely, Georgie. So we are working with many practices oh, I've just lost the lights in our room have just died. I'm so sorry. I'm back. Sorry about that. Live recording. We're working with many practices at the moment to assist them to review their arrangements. I think from many of the questions, as Georgie mentioned, are accounting tax related, and sadly it is an area where there isn't a one-stop shop, and you really do need to be looking holistically at your obviously operational requirements for your business, getting some tax advice from an accounting advice, as well as the legal aspects. We are helping lots of practices with the work arrangements that are in place and how those contracts are working to be hitting as many of the triggers we can see that are going to be helping practices to limit their liability. The key thing is that the document is not necessarily the magic pill. The law looks at the reality of the working arrangements. And so the contract is critical, but the contract has to work with the reality of the way your business is operating. And so I agree with Georgie that the first stop is probably your accountants to talk about the realities of your cash flow needs and how things are going to work for you operationally, to then be able to flow that through into a meaningful contractual arrangement that is going to best protect your practice.
Great. Thanks very much, Stephen. I had thought that we might have a bit more time to answer some other questions, but we've run out of time as always. Stephen, I think you've given a really good summary there and some key messages to take away. I'm going to turn to everybody else to give us a key message, and particularly to Tracy, who does need to tell you about a little development that we've had at Avant in a particular area, but we'll leave her to the end. So I'm going to turn to Mark first. Mark.
Thank you, everyone, for your request. There were so many questions that I'd really love to answer, but unfortunately we've run out of time. Certainly, if you find yourself in a very difficult situation where you feel stressful or you're unsure about the ethical obligations of saying no or meeting expectations, don't hesitate to call the Medico-legal advisory service and we can help you through that.
Thanks, Mark. Michael.
Thanks, Georgie. Look, I'll just give a plug for our next doctor-patient communications campaign, which is coming out. So please keep your eye out for communications about that. And please keep letting us know about any issues you're having with payroll tax so we can keep gathering your responses.
Awesome. Thanks very much. And Tracy?
I'd like to invite everyone to go and have a look at our refreshed health and wellbeing page, because it has provided access to Beamtree's wellbeing index, and that allows you to assess your wellbeing. And we've also put up a page for key support services. So just go to the advice and resources tab and we'll put a link in the chat as well. Thanks so much.
Thanks, Tracy, and appreciate that we've covered off a lot in this webinar. It is intended to give an overview of the topics rather than a deep dive. Appreciate that it makes it a bit tough to cover off in a lot of detail, but we'll certainly provide you with the resources so you can dive a little deeper, to use more jargon, into these topics at a later date. And certainly let us know in the survey of what more information that you would like to hear from us. So that really brings us to the end of the webinar. I can see people are jumping off, so please do the survey at the end. Don't forget about all the references and resources that are on the Avant Learning Centre. And I think that's all I need to do. So thank you very much. I hope you all have a good evening. Good night.
Good night.
Thank you.